A very warm welcome to everyone. Thank you for joining us today. For a very warm welcome to everyone. Thank you for joining us today for our panel discussion. I am Surbhi Verma, an advocate based in Delhi. I take this privilege to welcome you all on behalf of Law Insiders for the panel discussion on the topic 127 Constitutional Amendment Bill Decoding Path to Inclusive Development. Constitution being the heart and soul of governing the country has often been in debate due to its amendment. Recently, the 127th Amendment Bill was introduced in the Lok Sabha by the Ministry of Social Justice and Empowerment. The bill amends the Constitution to allow states and union territories to prepare their own list of socially and educationally backward classes. To discuss and enlighten us more on this, I would like to introduce and welcome our respected guests. Akriti Chaubey ma'am, we welcome you on board for the discussion. She is an independent litigating professional specializing in Supreme Court litigation and arbitration. She has an experience of over 9 years in litigation as well as investment treaty arbitration. She has managed litigation in several landmark cases before the Supreme Court of India, such as Ayodhya dispute, the entry tax matter, the triple talaq matter, and the coal gate matter. In the past years, she has successfully handled a diverse range of matters pertaining to constitutional laws, human rights laws, consumer laws, civil and arbitration laws. We are happy to have you on board, ma'am. Now, I would like to introduce our next guest, Abhinav K. Shukla, sir. He has worked as faculty and mentor at IMS head office, Mumbai, and career launcher for 3 years. Then he worked as an assistant professor of law at Amity Law School, Amity University, Chhattisgarh, for a year of 2.5 years. Recently, he has joined Hidayatullah University as an assistant professor. Sir prefers to be with students and mentor them rather than being in courts. We welcome you on board for the discussion, sir. Now, I would request our esteemed guest to take forward the discussion. I would start Akriti Chaubey ma'am to start the discussion.
All right. Thank you, Shukla. That was a very generous introduction. Firstly, I'd like to thank Law Insider for giving me this platform and also having me alongside of Mr. Shukla, who has this week previously taken a very, very enlightening session on this very same topic. So, without further ado, I'll just start giving you a little bit of background. So, the story of this entire 127th Amendment Bill begins from the 102nd Amendment Act of the Constitution. When that was introduced, that was the first time that National Commission of Backward Classes was being given a constitutional status in the Constitution. And at that time, when that bill was being introduced, the opposition had rightly pointed out that this anomaly is there in the bill, that you are taking away the powers of the states to provide for a OBC list of their own. However, the bill was still passed as it is, and 102nd Amendment Act came into being. And that's how this anomaly, the roots of this litigation, the Maratha litigation and the present bill were sown. So let me give you a bit of background, how this OBC reservation come into place, etc. So in the year 1980, it was the first time that the government had announced any kind of reservation for the OBCs based on the Mandal Commission report. But it was never implemented until the Indira Sahni case in the 1992. While hearing that case, the Supreme Court thought it fit to direct the central government, the state government, and the union territories to constitute a permanent body in the form of a commission or a tribunal for entertaining, examining, recommending requests for inclusion and exclusion of those castes which could be called as socially and educationally backward classes for the purposes of reservation. So, in accordance with that direction, the government introduced the National Commission on Backward Classes. It was introduced as a statutory body under the National Commission of Backward Classes Act, 1993. Now, the commission, which was a statutory body back then in 1993, it had the power to examine complaints on inclusion and exclusion of other backward classes, and generally advise the government about the welfare and whatever policies they're going to make about the OBCs. Now, with the 102nd Amendment, the object was very noble. The government wanted to give this NCBC, National Commission for Backward Classes, a constitutional recognition. Till that time, it was only a statutory body. So they brought out this 102nd Amendment Act, which was actually the 123rd Amendment Bill, and they inserted Article 338B in the Constitution. So with that, this body got a constitutional status, and it was also provided that all union, state governments will consult this body on all matters, on all major policy matters concerning the OBC. So with this noble objective, they also thought, so till that time, taking out of lists for SCs and STs was already provided for the purpose of reservation in the Constitution under Article 341 and 342. So what the government also wanted to introduce a similar provision for OBCs, because there was no provision for taking out reservation lists for OBCs in the Constitution till then. So what they did was that this was actually, if you ask me, it's an inadvertent mistake, but it was still pointed out by the opposition. They didn't, but still it was passed in the same manner. They took the same wordings of the SC/ST provision and inserted a similar provision on the OBCs. Now the problem with that arose was, for the OBCs, even the states were coming out with separate lists. But however, for SC and ST, that was not the case. Only president was in power. So now what happened, an anomaly arose that before the inserting of this amendment, before the coming into force of this amendment, states were coming out with their separate lists, the center was coming out with the separate list. However, this amendment inadvertently, so to say, restricted that power only to the center. Now, when this bill was being discussed, 123rd Amendment Bill in the Parliament, this was pointed out by the opposition. However, that suggestion never materialized, and it got passed in its original form. So an anomaly arose. However, even after that, the same old system continued. States kept on doing their own, taking out their own list for reservation, and the center kept on taking out its own list. The issue arose in the Maratha judgment case, when the state government had included Marathas for reservation. Now the Supreme Court scrapped this when it came to the Supreme Court, stating that the Maratha community, ruling that after the 102nd Amendment, the states had no power at all to notify any socially or educationally backward classes. So obviously now this affects a lot of other states who have taken out this list. So center obviously wanted this observation to go away from the judgment, and they filed a review petition on 13th May of 2021. I think 13th May they filed. 5th May the judgment came, 5th May 2021, and 13th May they filed a review. And on 1st July 2021, this review was also dismissed by the Supreme Court. The Supreme Court held that after the 102nd Amendment Act, the states had no power to notify any socially and educationally backward classes. Only the center had such a power. Now, to correct this anomaly, this 127th Constitutional Amendment Bill was introduced in the Parliament. It has, by the way, now become an act. Yesterday, only the President has given his assent. So now in this, when the 127th Amendment, in the 127th Amendment Bill, what were the changes that they brought in? Firstly, in Article 338B, which was inserted actually, we should first talk about 342. Article 342A, which was introduced earlier, in which the center had been given, the president had been given the power to make the list in the first place, and that was clause 1 of 342A, and any alterations to be done in that list, the power rested with the Parliament. 340A clause 2. Now they introduced, so they restricted these two clauses only for a list to be created by the center, and they called it a central list for OBCs. And 342(3) was introduced, giving the power, restoring the power, so to say, to the states and the union territories to come out with a state list. Then in Article 338B, Clause 9, which earlier provided that all the governments, whenever they are taking out any policy in relation to OBCs, any major policy matters, you are supposed to consult the National Commission for Backward Classes. That provision would not apply to this 342A Clause 3. Meaning, while taking out these state lists, they are not bound to consult the National Commission of, the states are not bound to consult the NCBC, National Commission for Backward Classes. And in 366, Article 366, Clause 26C, which basically defines the socially and economic backward classes. So they have, the meaning has been amended to include the lists of the central government as well as of the union territories. Now, very interestingly, when this discussion was going on, everyone has unanimously, this bill has been unanimously passed without any opposition, etc. Everyone knows. But there was a demand made for removing this 50% cap, especially from the legislators from Maharashtra, because they wanted to give more reservation than 50%. They said that in Indira Sahni case, which puts a cap of 50%, that should be removed. However, this demand was not acceded to, because in Indira Sahni case also they give a sort of a window that if there are certain extraordinary circumstances, the states can definitely go beyond this 50%, but there have to be extraordinary circumstances. And in the Maratha case, the Supreme Court has specifically observed that there are no such circumstances. In any event, when they held that the states have no power to come out with the state list, the issue was paused right there. But they also said that no extraordinary circumstances were there. So now, if you look at this bill was passed without any opposition, so to say, so there's no controversy really here. But if someone asks that, do you think it is a rectification or do you think it's a new provision? So in my opinion, I feel that when the previous amendment, 102nd amendment Act was being passed, and at that time, the opposition had specifically pointed out that you are, by bringing this amendment, kind of taking away the power of the states. And still the bill was passed in the same with the same text without any amendment, so to say, specifically providing for the states to also bring on their own lists. I feel when that debate one looks at, Supreme Court was not wrong in giving the Maratha judgment. They interpreted the text. The scope of the judicial purview is to interpret the text which is given. And in that text, especially after reading the debates, when the opposition has specifically pointed out to you that this anomaly could arise and you still go ahead and pass such an amendment, in that case, so hence, maybe people say it was an inadvertent 102nd Amendment Act was inadvertently worded like that, and the intention was never to do that. In fact, this was the argument of the Attorney General throughout the Maratha case, that the intention was not to take away the power of the states to come out with their own separate list. And in consonance with that argument, only this particular 127th Amendment Bill was brought about. However, once it is a question to ponder upon, that once opposition has pointed out to you that there is this anomaly in the bill, and still the bill, that amendment in that anomaly is not rectified before passing of the bill, and you go ahead and pass the bill, and later you cannot fall upon and say no, the intention was always that, because this anomaly has been pointed out to you previously and you have not bothered to include it in the bill. Anyways, coming to the 127th Amendment Bill, it has received the assent of the President yesterday and has become now an act. The good part is, rectification or not, this was the system going on since a long time. And what is the object behind reservation, if you ask me? The object behind reservation is to uplift the lowermost sections of the society, especially when the Constitution initially did not provide for socially and educationally backward classes to any reservations for them, and the court and even the government felt it necessary that there is reservation for scheduled castes and scheduled tribes, but there are no uplifting measures, so to say, for those people who are socially and educationally backward. And so the purpose was entirely to reach at the grassroots level of these communities who are educationally and socially backward and uplift them by giving them sort of a push by these reservations. because they will get opportunities slightly more easily, having been suppressed for so long, having not received opportunities at their level. So, of course, at grassroots level, it is obviously, when the object of the reservation is to provide the benefits at the grassroots level, it is obviously better, so to say, to give the power to states, because center is one thing, but the states are in charge of, it will help in these reservation benefits reach the grassroots level. However, there is one major disadvantage. I mean, that applies sort of to the central list also, but also to the state list, that now the states will be compelled by their local politics to, add more and more communities, and the cap remains at 50%. So I think because of this, we are also going to see an increase in litigation, where states now taking opportunity with this are going to add more and more community, more and more castes for reservation, and not being able to prove those extraordinary circumstances which are required to exceed this 50% cap. So I feel the controversy really is that to see whether how this gets implemented at the state level, and if the states abide by their constitutional duty, or they get swayed by their politics and add more and more communities, leading to increased litigation. I think that is the challenge in this amendment. So this is my two piece on it. And if there are any questions, I'll be happy to take them now or at the end of the session after Mr. Shukla has completed his part.
We'll take the questions at the end of the session. So now I request Abhinav to give his views on the same.
Thanks, Urvi. It was great to listen to Akriti now, explaining, because things are, if you talk about this particular topic, so things are very much interconnected, interrelated, and for that reason, confusing as well. So the way she was connecting and, from the starting. So as rightly explained and, rightly brought the major issues, major points into this particular forum of discussion, that, what was the issue, what is the issue, what was the issue, and why this particular constitutional amendment bill, or now to say the 105th Constitutional Amendment Act, it has been a topic for the discussion or talk, and whether it is a restoration or it is a rectification, or what kind of Constitutional Amendment Act it is. So to add upon few things which ma'am has explained, and further to talk about few more things in relation to this. One particular aspect, before talking about the provisions, before talking about the exact constitutional provisions or the clauses that we were talking about, one thing which is to be noted over here is, or something which we should observe, or which we may observe at times, is, there are some loopholes, or there are certain gaps in between the clauses, in between the provisions, and that is at there are some of the things which are not observed by either the executive or legislature, or even by the judiciary for a long time, until and unless it is brought to the court, or until and unless it impacts the people, it impacts the people at large, or the communities at large. The things are not brought into public discourse or discussions or considerations, or to the parliament. Like, one of those is the socially and educationally backward classes. If we talk about, as pointed out, that the first Mandal Commission, that is the first other backward classes commission, although it's not the first one, we had the earlier as well, the Kaka Kalkar Commission, etc. But the Mandal Commission was the one which was implemented later on. So before this, we did not had any uniform system of reservation, neither at the central level nor at the state level for the OBCs, nor in terms of the percentage, nor in terms of, or to simplify it, neither in terms of identification of the other backward classes, nor in terms of the notification of who will get, how they will get, and in what terms, in what percentage they will be getting. So this got clarity this got constitutional status at a very, or to say statutory status at a very later stage, in the late 90s. And then the things started working systematically. But what happened in the 102nd Constitutional Amendment Act and eventually now in the 105th Constitutional Amendment Act, this is something which should have been brought way back in 1992-93, as and when the Mandal Commission report was implemented. Because the Parliament, the government of India, while implementing the Mandal Commission report all over India, uniformly throughout the nation and also depending on the states, it gave the power to the states. It took the powers, which means the power were also given to the central government, the president, for the identification as well as for the notification. But in the Constitution of India, there was no provision, unlike for the one for SCs and STs, that who is going to notify, who is going to identify, etc. And the things continued in the same manner till 2018, 2015-16, when the 102nd Constitutional Amendment Act was brought. Which means for these many years, the things were not in the Constitution, not mentioned in the Constitution. The question was not raised in the Supreme Court regarding this. The question was not raised in the public discourse. The controversies were there, but they were mainly with regards to identification and the percentage of reservation, which is still there in the course of discussion. But what about the process? What about the constitutional, provisions, etc.? This is one thing which I wanted to point out. Second, which I also said that, until and unless the things are not brought as a matter, as a case, as a case law in front of the Supreme Court, till then, some of the things are there which exist in the Constitution, but are neither pointed out nor clarified until unless brought to the Court of Justice. And in fact, in this case also, it was not brought directly, that no one had pointed out that whether there is a constitutional flaw in it or whether there is a, there is a loophole in it. This is actually a matter which was brought incidentally. The main matter of discussion, the main controversy was Maratha judgment, Maratha reservation, extra 16% being given to them. But incidentally, the more important constitutional question had come into this particular Court of Justice, that whether the states should have, or whether the states do have any power anymore. They have this power after the 100th Constitutional Amendment Act. Answer was no, they do not have this. So we can see that, since last 3, 4, 5 years, the states were identifying, the states were notifying. But now it is now that the Supreme Court has, brought and clarified the matter. This is something which has also happened in a lot of matters earlier as well. But what suggestion or, what kind of thought this gives us, that how can we, or how can the nation, a democratic nation which runs completely solely on the basis of the Constitution, what can be done to work upon such things, that, in the upcoming days, such loopholes in two ways. First is an amendment act which was supposed to be brought quite earlier, whether it regarding that. And second, the most important aspect is, whenever a legislation, or to say a constitutional amendment act, which has a very huge impact on the nation, for the years to come, for the generations to come, there should be an analytical constitutional legal study of the constitutional amendment bill before getting the final assent of the president, before being passed by the parliament. And I am talking about this despite the fact that we know there are standing committees, we know that there are committees within the parliament, but we do need a specialized body. And this idea I would like to relate with the recent Supreme Court, judgment, or recent Supreme Court comment. If we know, or if we are aware about the tribunal ordinance reforms, that has been tribunal reforms ordinance that was brought by the parliament. And regarding this, the Supreme Court of India gave a judgment, passed a judgment, the Balaji judgment, I guess, in 2020. And in that judgment, the Supreme Court has, pointed out that there should be a national commission for analyzing the impact or effect of a legislation before it being brought. Because if the legislation is not up to the mark, if the legislation is going to create certain loopholes or going to, bring upon certain such lacnas, it is going to increase the, burden on the litigation on the courts. And not only just, it's not only about the increasing of the litigation or, the burden, it's also about the impact it is going to have. Like, if we talk about the significance, the importance of the 127th Constitutional Amendment Bill, which is now the 105th Constitutional Amendment Act, it is going to impact 671 castes all over the nation. Which means if this Constitutional Amendment Act would not have been brought, 671 castes all over India would have been deprived of the benefit of reservation that they are going to get. And why was it supposed to happen? Just because of a fact that the 100th Constitutional Amendment Act, 102nd Constitutional Amendment Act, if it would have included just one clause or a clarification in it, all these situations would not have come into place. Therefore, these are certain things which, the legal system, the government, and the judiciary keeps on commenting, judiciary keeps on giving suggestions on these particular aspects. But this is something on which the government and the parliament should work on, having a permanent, final committee, whatever we say, not in the form of, which should have legal experts, which should have members from the government, from the legislature, from the executive, and from the judiciary as well, to give their suggestions upon, to work upon it. And then finally, this should come into place. So these are certain things. This is again, see, there can be a question raised that is it not going to be an encroachment or going to be an attempt to restrict the power of the parliament, the exclusive power of the parliament to amend the constitution? Isn't so? So the answer is no. It's only going to analyze the impact, and it is going to work upon not going to encroach or not an attempt to affect the power of the parliament, but to save such situations which have arisen. So these are certain things, these are certain views which I wanted to give, talking about the impact of what has happened in between the 102nd Constitutional Amendment Act and in between this 105th Constitutional Amendment Act. This is what has happened. So I would, happy to take the discussion ahead with certain, yes, ma'am.
May I just interject and
Right.
I differ from you on 2-3 points, actually. The thing you just pointed out that, there was a lacuna for so long and the court did nothing. We really cannot blame the judiciary.
Correct.
Because whenever they take some action, they are blamed for overstepping their jurisdiction. And why should they interfere in a policy matter unless no one is challenging it? It is not in their sphere to take a suo motu action. I mean, they could, of course, 142 and all is there. But I'm sure if they would have done it suo motu, there would have been a huge criticism that they're overstepping their boundaries. So we really cannot blame the judiciary for this. Yes. I have to stand for the judiciary in this one. Because there are many cases in which questions of law arise and they come up to the Supreme Court. And the Supreme Court says, no, in these facts, we don't want to interfere. Even though there is a question of law arising, we will leave the question of law open to be decided in a case with appropriate facts. So in this case, honestly, we cannot really, and you pointed out that this question was actually raised incidentally and it was not directly raised. But we really cannot say that the judiciary did nothing because they are supposed to do nothing until someone challenges it. And secondly, this permanent body, which the Supreme Court has also pointed out in their recent judgment. The thing is, I feel it's my personal opinion that there is already a system in place. There are parliamentary standing committees. All of these MPs, they get OSDs too, which they can, if they feel someone is good at their work, they can appoint an OSD to assist them with all this. There is a very well-trained bureaucratic system. We have the executives. In fact, for many bills, you will see that they put up public notices. They invite the comments of the public. They invite the comments of the parties who will be interested in such a bill. So all that system is in place. It's not implemented as well, I feel. Of course, having a permanent body would streamline the process and make it much, much more quicker and efficient. But even with the existing system, for instance, in this 102nd Amendment Act, what happened? It was not like they did not know about the lacuna. This lacuna was pointed out in the parliament. So for this particular instance, the permanent body was not a solution because it was pointed out to them. They still went ahead with it. Of course, going forward, this permanent body is a very, very, encouraging step because, all the comments, of course, they give up out of public notice. They must be getting hundreds of letters every day, hundreds of opinions every day, hundreds of suggestions. It's not possible for any sitting MP or for even for a bureaucrat to go through all of these suggestions. So obviously having a permanent body would streamline this process. But for this particular bill, when this lacuna was pointed out and they still chose to go ahead with this, the permanent body is not an answer in my opinion for this bill. Of course, going forward, it's a very, very good idea, and we should because see what this happened. For such a small lacuna, court wasted its time for almost, I think the hearing went on for almost 2 months,
right,
more than that. And then parliamentary time was wasted again. This is all whose money? This is all the public's money. So this is a waste of the precious time of the legislators as well as the judiciary. So, of course, a little bit of caution at the time of passing of the 102nd Amendment Act would have helped us in saving all of this time. But nevertheless, at least it has been corrected and the balance has been restored. So that is all. That is all I wanted to point out. We really cannot blame the judiciary for this.
right. No, I agree with you. Like, at this place, we cannot, it's not at all about blaming the judiciary. Because of the fact that, first of all, their hands are tied. They are restricted. They are bound by a certain system. They cannot overstep because of the separation of power mechanism that we have. Yes, they do have certain such powers or jurisdictions where they need, which we call the judicial review, but that is not applicable, or that cannot be brought into place into every other such things which happen, because even in this case, if we talk about, yes, it is not at all about blaming the judiciary. Even if the judiciary is observing, first of all, considering the plethora of cases that they have, etc., it's not every legislation that is coming, the judiciary will analyze it, then take it so motive. This is not at all a part of system, and this cannot be done as well, because yes, it will be encroachment, it will be overstepping, etc. And the EIA, I got one example related to when you were talking about that the government do get a lot of suggestions or public letters, or they put the bill into public discourse for discussion. They ask for the public suggestions. In this regard, the EIA draft 2020, which is still pending, which is still to be notified, it received about 17 lakh public comments, which is definitely not possible for the government to go through and getting the things done, etc. And as pointed out that yes, opposition had already pointed out that yes, this is a possibility, this might happen in the upcoming times, that the particular clause which you are not considering into fact, this is likely to, and that's what exactly happened. But consider, what happened is the opposition did point out. And as soon as the 102nd Constitutional Amendment Act was passed, this was, if the opposition pointed out, and this was into place, that yes, the states are now restricted, impliedly, not expressly, but impliedly. But until and unless the court will not declare, they were allowed, they were free to do so, they were doing so. But no one had raised the issue in the court.
I will tell you why. Which political party is going to go to court and say that restrict my powers of reservation? Who is going to do it?
No,
it was political suicide if they do it for their own state or for any other state.
Correct. It was like, no, because see, they pointed out the same in Parliament, that yes, our powers are going to be restricted. So for a better clarification, they could have reached the Supreme Court that we want a constitutional interpretation from your side, that are we allowed or not?
For a constitutional interpretation under the advisory jurisdiction, the government would have had to approach.
The government would have.
The government already saying, no, there is no lacuna. We are giving powers to the state. We are not going to write it in the amendment, but it is there.
But in this case, the Maratha judgment, which is Jayashree Lakshman Rao case, in this case, the basic structure was also brought into question. It was raised. One of the issues were that it violates the 102nd Constitutional Amendment Act, violates the basic structure, because it is affecting the federal structure. So eventually this is, so that could have been brought as a case regards to basic structure.
Exactly this would have happened if they would have come to the Supreme Court. Supreme Court would have said that I cannot go beyond the amendment. The amendment
Right.
says your powers are restricted. No political party would have wanted to take that risk.
So it's just like till the things are not pointed out and not noticed.
From making lists for their own people in the state, they will. Right. No one would have wanted that power. Actually, no one wanted that power to be restricted.
Correct.
Even after it was restricted, things went on like that. No one challenged it. And over here, also, it got incidentally challenging. So this would have gone on like this. I'm telling you.
That's what I said. It's just like, right. It's just like till the things are not pointed out, till the things are not, brought that you don't have the power. No, you no more have the power to it regarding this. So it's like till the things are going on, let it be. It's just like jaisa chal raha hai, chalne de, sort of like let it be. So until unless not brought into that impact. But
it was brought at the time of making the amendment. It was brought to their notice. They are saying that mention is there, but they don't want to include it in writing.
Don't want to include. So yeah, that's there.
I think their refusal itself showed that there was a clear case of taking away the state's power. So anyways, it went on. Now they've at least they have now rectified. Everyone is on the same page.
The state. The center has rectified the center, but yes, in this regard, although you had clarified on this that the judiciary had to interpret it accordingly, because we do have Article 340, 341 in the same, with the same wordings, with the same text, 341 and 42.
And once the discussion on this has happened and it has been pointed out to you, just see, obviously parliamentary debate is not it is not the set stone as to you have to interpret the bill like this, but it's an aid to interpreting the amendment.
It's an aid.
Once you see that this was pointed out to the government, it was, and though no amendment was made, which makes it amply clear that the intention was to actually exclude the states.
In the same manner as the court interprets while interpreting in constitutional provisions, they take into impact the Constitutional Assembly debate. And yes, and it's not the final decision that they consider always. They the debates.
Also, that it is not the final decision; it's only an aid. We can differ from what was discussed there.
Aid.
Definitely.
Yes, if we talk about that, when the opposition had already notified, pointed out that yes, this is something which is likely to happen. So even by going by the parliament's or the government's intention, this makes it quite clear that yes, they had the knowledge of this particular thing. Still, they did not, bring this particular clause into this impact, and the result, the outcome which we can see as of now.
Your point about this going on like this till the time no one has pointed out this has happened. I mean, this has actually increased the burden of the court so much.
Correct.
Not only in this case, if you look at the entry tax matter, since 1980 Atiyabari, the law was settled, so to say. 2019, 2018, 17, I think 18 or 17, 2018. They changed everything. The interpretation was not there, not disjunctive. And so, of course, till the time no one points out, and in entry tax, though, I think there were almost 300 or something batch matters in the Supreme Court only, which would affect all the states. So you can imagine that this kind of issues are only decided when someone brings it to the court. No court would, in fact, especially because of the reason that the courts are so overburdened, they wouldn't want to take up such a huge burden.
Right.
On their own.
I think also while interpreting things like this, like especially if we talk about this, which has now the court has said that states do not have any power. But I think the states, yes, the judiciary, the court, the bench has taken into consideration the fact that since last 3-4 years, the states have already been doing so. And if I'm not wrong, the court has taken the prospective overruling aspect in this as well. If I'm not wrong.
I'm sorry, I missed you. I think there's a slight connection issue. I missed the last line that you said.
The prospective overruling part, I'm saying, the court would have taken into consideration the aspect that the states have already been identifying and notifying it since last 3-4 years. We are today declaring that the states do not have the power after 102nd Constitutional Amendment Act, 2018. Yes. But if the court would have said that, void ab initio kind of, which means the last 4 or 5 years of identification and notification, that also would have been declared as null and void. But I think the court in such matters take into
They have
consideration.
taken a liberal view in the sense, obviously, you cannot undo what benefit has been given since 2018 till now. You cannot undo it. And the government has acted with much urgency in bringing out this amendment to restore the balance. So,
Correct. The same thing which the step which they took in Keshwan and Bharti as well, which means we will, yes, these are unconstitutional and basic structure, but today onwards, not overruling it in the retrospective aspect, but in the prospective manner.
This has to be this has to. I mean, we have to give the credit to the government that they just brought it immediately. I mean,
yes,
as soon as they could deliver it.
In fact, this is something which they could have considered it as an aspect that, restricting, if we talk politically. Politically they could have that we need to, the court has allowed us, and unless the new government comes into place, the new Constitutional Amendment Act comes into place, we can very much restrict the governments all over India, those who do not belong to our, political party, let they not be given the power to identify and notify, but we can do so for the center, at the center
of the government. The Attorney General in the court had not taken this argument. They had always said, supported the state's power. So that much credit you have to give to the government. Even if they made a mistake, they knew that it is going to come back, and people are going to say, even in the parliament this time, in this 127 bill was being discussed, people said that you made a mistake, you did not listen to us at that time. They knew all of that is going to come, but they still took a stand, knew the power, the intention was always together. So that much credit you have to give to the government, that they knew that all of this is going to come back to them, and they still took a stand that the states have always had the power. Of course, and they did not make things political about this. This much credit you have to give. It's not easy to accept a mistake at such a large. This is the largest Parliament of India, is the largest platform in the country. They have accepted their mistake and rectified it with immediate effect. And in fact, if you look onto the clauses of 341A, 2, 3, and then the changes brought in 366, 26C. Then this 338B. So they have left no scope now. This time they have, with abundant caution, yes. They have studied their amendment. Like, I think maybe at one particular clause they could have added a word, or adding up one clause would have solved the purpose. But now they have considered that all the clauses that we have, all the articles that we have, they need to be crystal clear that there is no scope of further such interpretation, broader interpretation, or anything as such, which is going to restrict the states at all, in any case. You must give credit to the law officers of the court also, of the government of this country, who had made these very arguments before the court. So it, when it came to the parliament, this issue was already so well researched by all the, top lawyers in the of top government lawyers, the attorney, and the legal experts. Yeah. So I mean, it's good that they went with their advice, and it was very well researched to leave for no scope for misunderstanding or for frivolous litigation in the future. Right. And that is one important aspect that I think you already mentioned with regards to identification. So this whole judgment, this whole controversy, the 127 Constitutional Amendment Bill 102nd, was all about notification, which means the power to notify. The center's power and the state's power both will have the exclusive powers to do so. But I think with regards to identification also, there have been some interesting comments given by the court in this case, because the Maratha judgment eventually was about identification, which turned out to be a case of notification. Yeah. So identification was the main and notification was incident. But with regards to identification, if we see, so they have specifically looked in a very detailed manner, which I think Bombay High Court also missed, or Bombay High Court, because Bombay High Court gave quite a different kind of suggestion that instead of 16%, you give 12 to 13%, that would look sufficient. Or they said there are certain extraordinary circumstances, but not to the extent of giving a 16% reservation. So you come down to 12, 13%. It was a very like a bargain sort of a judgment. Bargain sort of. Yes. How can we expect a constitutional court to say that, instead of 16%, if you give, and they did not give a specific number. They said 12 to 13%.
This
And as a court, you don't have the power to do that. You either strike it off or you keep it alive. You can't be like you make, or you say that we are going to suggest. You cannot direct the government ki you bring
Right.
a reservation to that much.
You are being asked, your authority is up to suggest or to declare that whether this is right or not.
Accept or reject. You can't say that amend it to bring it like this. And even if you say it's a mere suggestion, the government is not bound by that.
Yes. And in this regard, if we see, the components which the Supreme Court has considered very minutely, and that's one of the reasons why the marathon hearings were happening in this case, was they had brought into consideration, or they had, considered each and everything with regards to the public employment of the Marathas in central and as well as the state level.
And they say that almost 25% of the community is well represented, is in good, it's in good professions, and they're not that there are no extraordinary circumstances to say that they are backward in this sense. These arguments were definitely taken up before the court.
Taken into consideration.
The entire purpose of the reservation is to empower the socially and educationally backward classes, and that kind of purpose was not found in this. Even if suppose they did not strike off they did not say that the states did not have the power. Even despite that, this quota would not have withstood the stand of that 50% cap by extra 16%.
By extra 16%. Yes. And I think that, this particular aspect of identifying a new caste, either in the same existing aspect or, giving them extra percentage exceeding the 50% cap, which is again, as we can see, the opposition demanding upon these things that the 50% cap should be removed. This is not exactly a good idea, which seems to be, in this particular aspect, because it's not that if you have more population, you need more reservation. It's about if the population is more and the population needs it in the equal aspect, in the equal ratio, then obviously you can do that, as we have it in the state of Chhattisgarh, we have in other states where we have more than 60%, nearing 65%.
In those states, the situation is very different. They are trying to inculcate some, sideline caste into the mainstream population, the mainstream population of the state. So in those cases, definitely, there are extraordinary circumstances. These castes have, not been exposed to any sort of education, or, they are being introduced for the first time to the mainstream population. So in those cases, definitely, the case is made out for more than 60% reservation. But I feel in India, I feel in the last few years particularly, this has become a trend that each community will get together and they will say, they will demand for reservation. No one wants to work hard. See, if you are eligible for reservation, you are also eligible to compete with the regular quota. Why don't you work hard? That's the whole point. I remember I did a very interesting case. I think it has been now 4-5 years ago. So there was a district judge. Both of his sons moved. I think district judge. He was a district judge in Bihar or something. And both of his sons moved to the UP. They were a protected, like a reserved caste in Bihar as well as in UP. So, but you have to show the domicile of the place where you are residing.
Correct.
They showed false domicile. They got through the district judge exam in the UP. So he got through this. So both of the sons took the exam. One of the sons got through, and he was. He started, holding court, etc. And the person who was below him, he challenged it, saying that this person doesn't have the domicile of Bihar, and he should not be given reservation.
Benefit of reservation.
Benefit of reservation. He is domicile of Bihar. He is not domicile of UP.
Right.
So even if he is included in this, even if the same caste is being notified in both the states, it doesn't mean that he can take the benefit here. He has to take it in his home state.
Definitely.
So the matter came up, and I remember it was at that time Chief Justice Thakur was holding the court.
Okay, Justice T.S. Thakur.
Yeah. Justice T.S. Thakur was there, and it was, he applied, he just, impromptu, the clients were present in court. He called the other person who had challenged this appointment. He asked him, what is a plaint? He had no answer. He asked him, what is, आपने practice तो करी होगी court में, plaint क्या होता है, plaintiff क्या होता है, defendant क्या होता है. He had no idea. So Justice Thakur goes to the other side and asks them, asks the lawyer, that you want this person to be a judge, what is going to happen to our country? And then he turns to us. I was representing the person who had wrongly taken the, now I can say wrongly because the case is over. And that is what the judge has said also. So judgment is also to that effect. So he asks me that, see, what is the purpose of reservation? It is for socially and educationally backward classes. This person, I mean, this was all off the record. It wasn't featured in the judgment.
Yeah.
So he said that, this person, he is a child of a sitting district judge. I mean, of a district judge. That time his father had retired. Does he need the reservation? You tell me. And I had no answer. Of course, this is not what reservation is. Reservation is for grassroots level. If your one generation above you has already, for OBCs especially, it is for educationally and socially backward. SC/ST is a separate this thing you have been. But for OBCs, it is for the two parameters are educationally backward, socially backward. This person is a district judge's son. He has had the premier education. He is not socially backward. Actually, even in Bihar, why should he be getting reservation?
Yes.
Anyway, so then very innovatively, Justice Thakur wrote a judgment. He said that I am going to relax the age limit for both of you. You give the exam. If you pass, I will allow you to remain in service, and we will allow, of course, if you pass, then you can also become a judge. But this cannot go on like this. No reservation for both of you. They were both, only age limit was relaxed and permission was given, liberty was given to them to take the exam again. But so these kind of things come up, and that is the whole problem. Why more and more reservation is being asked for is the benefit is not reaching the grassroots level.
Yes.
The people who are at the grassroots level, they don't even know that there is a provision for reservation for their kids.
And yeah, I think
what happens, the people who are, a little well placed, they are aware about these provisions that their kids can get, and they are not the people that these reservations are targeted at.
I think, yes, this is a very fundamental issue, very fundamental problem, and not only with the other backward classes. This also remains the same with regards to the scheduled caste and scheduled tribes, which means the same family or the same group of people, they are generation and generation again and again availing the benefit. They are, yes, obviously allowed to do so because creamy layer is not applicable over there. But if we talk about these grassroots level people, or the people who are still not into the mainstream, the problem is, first is awareness, that yes, they do not have
awareness is the answer.
Yes, they do not have the awareness about these things. But I think even more than awareness, the problem, because see, if you look into the benefit of reservation which one is going to get, at what stage of life? They're going to get it at the stage of life, after they complete their school education, either into the entry for the educational institutions like the higher education, or in the public employment. But for that, a minimum basic education is required in all levels, which means not only in terms of getting the certificates of these things, but at least a basic minimum education, the school education, the elementary education up to 12th standard is required as needed. Now they are not going to through all these things. They are not going through this process. So it's not a kind of awareness that we go to the tribal area or to the forest area and we awaken the particular tribal that, see, you get this benefit. Now your child is what age? He is 15 years of age. So send him, he'll get the benefit. No, if he has not gone through the process of school education, and that
process, I feel you have,
yes,
you have to empower them right from the beginning. At the primary level, there is, you have to ensure that they are undergoing that primary level of education, even under the Right to Education Act, what the 8th standard. You can avail education. What after that, these reservation in these premier institutions is not for people who have dropped out after 8th standard. So definitely there is a need to strengthen our, primary institutions.
Primary school education.
They have also taken out this economically backward classes quota for all the private educational institutions. They have to 15% give admissions to. They have to see that all this is actually implemented, because many schools are still not implemented. Just like for private hospitals for treatment, they have to give 10% OPD, 15% IPD, reservation. This is not being done at the grassroots level. This has to be checked, and
implementation is
COVID, so many people, so many people who are economically backward and educationally backward, they have dropped out of classes because firstly, they no income in the household, and secondly, they don't have the means to connect through the internet. I mean, if you can say that, recently we have seen a lot of lawyers have also been protesting that not all lawyers have the facility to
Correct.
attend courts virtually. Can we imagine if a professional body is saying so, then what is the status of these so-called backward classes? So it is not a change which can be brought about in a day. It's a whole movement which is going to
It's a process. It's a long process, and the most important aspect is the changes needs to be brought at the very grassroots fundamental level, and with those people, with those group of people, with those classes which are still far away from the mainstream.
Yes,
in all aspects.
Not even a point of discussion, Abhi. Though
Yes.
there is not even a point of discussion. Primary education is not a point of discussion in any way. So,
And because this particular aspect which I was talking about, this is very much evident at places where they do have secure number of reservations, but the minimum number of applicants are also not available in a lot of public employment, especially if we talk about the government higher education institutions, the IITs, the IIMs, a lot of in every field, because the number of reservation is fixed. They will get 27%, 12%, 8%, 7.5%, all these. But for that, you need to go through the whole educational process, UG, PG,
foundation needs to be there, otherwise you cannot directly one day get up and go to a professional institute.
Yes, so the seats are vacant for years and for decades. The seats are vacant and the government is helpless in this regard because of a lot of restrictions, the state restrictions, the central restrictions, etc. So these are certain fundamental things which rather than talking about increasing the percentage of reservation, the focus should be on how to work upon these particular aspects and
how to make the best of the system that we have right now. First we have to master that, then we have to see that the reservation system is not, I mean, if you see, it's not working as it should have been.
The original intent or the goal or purpose is not served.
It's not served till now. Why? Because of the implementation.
Implementation is the key, indeed.
You cannot half-heartedly implement something and then wait for it to work and then say that no, this is a system failure. Reservation has never worked, so we should not increase reservation.
Yes.
So we have to first ensure that the implementation is up to the mark, and then only we can decide whether it is working or not working. It is very easy to say that since the independent, this has not worked. I mean, I see many critics saying that why to increase reservation, why to give reservation, because since the independence, we are seeing the same thing, it has not worked. But why has it not worked? Because of poor implementation.
True.
So these are issues which still remain, I think, for another day's discussion.
Also, what you also mentioned that this has become a trend. We have seen since last few years. We saw the Jat reservation, the huge violent movements also that took place at some of the states. We also saw for the Patels that happened in Gujarat. We saw in Rajasthan. We saw it in Maharashtra for the Marathas. But what we need to see is even the governments they are not free to do so. They are bound by these kind of rules and regulations. And the Supreme Court again and again in judgments like this Maratha judgment clarifies it that no, you cannot, until unless you are having quantifiable data to prove that this particular caste needs reservation or extra reservation, you cannot identify and notify them as these kind of things. So the Supreme Court, even this particular judgment, has worked for that particular manner.
What political parties are motivated by something else.
Yes.
Not only the law, and also, so see, now it's very easy for them in the next, to justify to the public that the political will was there. We did it for you.
Yes, definitely.
So sometimes you see most absurd laws being passed at all levels just to show to the people that the political will was there, and it is not our fault that this has not happened. This is not
questioning. They are not in question. Yes.
So just to shift the burden from their heads to the court.
Indeed.
That is it.
Correct. That's we had the political will, we provided it, we did it from your side. Now it is upon the court to do so, and the court has done this. So we are helpless now. So just to clear their image or the political will, which I think is not, yes, technically, constitutionally, legally, yes, there are things. But working in those particular positions or working in that particular aspect, it's a part of the democratic process that yes, people are demanding. If you are in power,
we are there because of the people's votes. If they feel that if we don't remain there, whatever good also we are doing, we will not be able to do. So we will take one of this, as a thing to keep us in power, so that we can do the other welfare schemes that we are putting into place, at least we can go ahead with that.
Right.
So it obviously, for both of us being lawyers, and we will not appreciate these kind of,
Definitely.
but it is a part of the system, and I don't think anytime soon it is going to go away.
This also, takes us to the particular thought that there is still a huge gap between the legal reality, which means legal reality, if I say the interpretations by the courts and etc., and the ground level reality, which is about the public perception, which is about the public demand, which is about the public rallies or such kind of moments to gain the things. There is a gap. The gap is because if everybody is very strictly aware of the fact that no, this is not allowed constitutionally, even if we demand, even if we get that, the court is going to struck it down. So there is a huge gap between these things, these two particular ends, I guess.
But they take the risk to clear their image. What to do? So Survi, are there any questions?
Yeah, the question is, what would your suggestion be on the percentage of reservation?
What to say? Honestly, I feel that there are sometimes, extraordinary circumstances. Like, just as I pointed out, we were just discussing this, Mr. Shukla and I, that there are, times when you are inculcating a totally, secluded and a totally protected class into the mainstream population. In those kind of cases, the people who are cut off for ages and, they have never had access to the mainstream education. In those kind of cases, to inculcate them into the mainstream population, it is necessary. However, I feel it should not be encouraged, because reservation was meant as a tool to temporarily assist you to get to a place, right? And what is happening is, till the time we get our implementation right, I don't think we should, do away with the cap, because what the problem is that, 50, 60, 70, you will give them reservation. But if the benefit is not reaching to the lowest of the lower level, then there is no point, because then one person is a doctor from a reserved class, his son will take the reservation, his son's son will take a reservation. So in this manner, this is not the development which the reservation seeks to bring. The development which they seek to bring is one person who has availed the benefit. Their next generation should not be needing reservation. They should be going through the general class quota. Now, increasing will only make people dependent on it, and people will not strive to give their best. So I feel that, of course, extraordinary circumstances are there, and that is why the court has, put in a disclaimer over there that in extraordinary circumstances we could do away with this. But as a matter of fact, we should not do away with it. That is what I feel. And I mean, till the time at least we do not master the implementation of how much ever percentage is there, and we make sure that it reaches the grassroots level, there is no point in amending and going on increasing the quotas without the benefit reaching to the marginal level people. So that's my opinion.
I would also like to comment in this aspect. See, when we talk about the percentage of reservation individually or as a cap, if we talk about individually, we do have it for the SCs, it's different, for the STs, it's different, and for the other backward classes, it's different. Uniformly, it is the same, like 27%, 7.5%, 12%, like that. But yes, it differs from state to state as well, etc. But behind the logic, the reasoning of fixing a particular percentage or fixing a particular cap, it has never been randomization, which means it's not that the government has on some random basis brought the number of 27, or so on some random basis the Supreme Court has fixed the percentage of 50%. It looks 50%, half reservation. It's not that. There are legal reasonings, logical reasonings behind this. Like, for example, if we talk about how this 27% for the OBC reservation formula has come. So for that, we need to go through the recommendations of the Mandal Commission, which were also considered by the Supreme Court in the case of Indira Sani, both the 9 judges bench as well as the other one. So when we look into the formula, they had brought into the aspect that we have these many crores of people who belong to the other backward classes, who form the 50%, about 50% percentage of the population of India. So out of that formula, the 27% formula has come into place. Similar is with the case of SCs and STs as well. And considering all these reservations, the Supreme Court has fixed the cap that, see, when we calculate the major three reservations of India, the OBC, the SCs and STs, it falls somewhere around 45 to 47%. So keeping a scope or giving a scope of 3%, the cap should be on 50%. This is how the 50% cap has been brought. Now, the logic of why or how the 50% cap has come, or the different caps have come, this is what it is about. So it's not that, because we need more reservation, so let's increase the reservation. Because, see, it's very important to consider over here the practice of the cap of, or the limitation of, creamy layer, which is applicable on the other backward classes. What is the reason of applying this creamy layer concept, which is right into place since 1990s when in the Indira Sahni case, the Supreme Court declared, which means if you have above this much of annual family income, if I'm not wrong, it is right now 8 lakhs per annum, the annual family income, you and your family members are not eligible for the OBC reservation. You cannot avail that. What is the reason behind this? The reason is, suppose you got the benefit of reservation and you have become a government officer, let's say class 1 officer, class 2 officer, etc., or you are into any other such profession, your annual family income will be above the limit of 8 lakh rupees, which means there should not be generational. The reservation should not be generational. It should not become perpetual. It should be on the basis of who needs it actually, they will get it. And this is how people who get the benefit of reservation, they keep on moving out of the list of OBCs or the group of OBC reservation benefit, because they move into the category of creamy layer. But yes, this is still not applicable in the SCs and STs. So if we look into this particular logic, the people are getting the benefit of reservation since 1990s for OBCs. They are becoming socially and educationally and economically upward, and they are no more eligible to get the reservation. So if you look into the ratio of increase in the population and the benefit of reservation which should be given, increasing 50% limit of reservation is not at all something which is required or needed. So this is how it works. This is how it goes. And considering all these aspects at this point of time, yes, there is no need of it at all.
Okay, so that's all the questions we have for the session. So taking it forward, is there any more discussion between, you would like to ask some questions ahead, ma'am?
Oh, I think I would just like to thank Mr. Shukla, because I really enjoyed this discussion, and definitely his past session and this session, both of them have enlightened me a lot. So I would definitely like to thank him, and thank you and Law Insider for giving me this opportunity to.
Thank you. I also would want you to take my, vote of thanks as well for that regard, because, the litigation side, the court side, and the arguments, the experience from that particular aspects that you have brought into the discussion, that adds on to the overall topic, the overall, area of discussion that we are having. So thank you very much for that as well. And yes, it was great having the discussion on with some common, with some differences, not differences actually, but a clarity on some of the things, which yes, we have brought the clarity on that particular aspect, and to adding upon the overall developments that have taken place.
So thank you to our guest for such an insightful panel discussion. It was a pleasure to have you with us for this discussion. So we conclude this webinar. Thank you to all the attendees. We hope you enjoyed this insightful panel discussion. Thank you.
Thank you very much.